A professional with specialized knowledge in laws, codes, and standards relating to accessibility requirements for the persons with disabilities. And so, I'm also the Certified Access Specialist Technical Administrator, and that means I get a lot of phone calls from business people, business owners, particularly small business owners. And I know that there's a real fear that you fear getting a lawsuit for access violations. And it's not clear how compliance is determined. That's why my message is hire a CASP, be proactive, and get legal benefits. Because the route to being compliant is not as clear, it's a bit murky, and so sometimes, you gotta just hire a specialist. And so I'm not here to sell you another program that's a state-funded program. And in fact, the Certified Access Specialist program is voluntary, and there's no law that requires any of you to obtain CAS services. Instead, what California law does is it rewards and incentivizes business owners who take that proactive decision to voluntarily hire a Certified Access Specialist to get informed and get compliant. Because we all want to be in compliance to the laws that we're subject to. And so, what is compliance and how is it measured? And so compliance is determined to the applicable standards. And what that means is, if you have a facility that was built in the 80s, the applicable standard is the standard that was in effect at the time your facility was constructed or altered. So what it doesn't mean is you use the current standard to determine or measure the compliance of your facility. And so what is a standard? A standard is a list of requirements. It's a booklet or a book of requirements. It's law. It basically contains minimum requirements of a built environment. For example, a minimum width of a doorway, that's defined. And that's defined as to facilitate a person in a wheelchair to traverse or go through. Height of certain accessible features like a countertop, clear floor space areas near doors. So those types of technical requirements are indicated. These are standards, requirements, they're law. So, and most complaints are cited to violations to the current standard. And we don't use current standard because let's say you had a building built in the 80s, and current standard is the 2019 CBC, for example, for California. Way different. You're going to have maybe 30 pages of standards to today's 211 pages of standards. So you don't want to use the current standard because you're going to be making an assessment of a facility and performing an inspection to a higher standard. Okay? So by law, it's to the applicable standard. And so by law, California says to be in compliance, well, actually at the federal level as well, you have to be compliant to the applicable standard at the two levels, state and federal. State is the California Building Code. This way, California Building Code, that is building code. And the access provisions, the access requirements for your facility is based on the use, okay? Now, federal level, different. The standards are very similar, but federal level, you're talking about a civil rights law at the federal level. And these laws, this obligation is directed at you, the business owner, and what it says is, ADA, Americans with Disability Act, passed in July 26, 1990. What it says is, if you are a place of public accommodation, and what that is a facility, so if you provide goods and services to the general public, you are a place of public accommodation, and you are required to provide full and equal access, okay, and that includes physical access.
So that doesn't apply, the applicable standard doesn't apply to that?
In the context, no, applicable standard is you have both federal and most of your facilities will have two standards. a California standard and a federal standard. But what I mean by applicable is they're different levels. We'll go to the next slide and you'll see. So let's use this example. So this is Mary Jo's Cafe. It's about 2,000 square feet. There's a dining area. There's a counter. There's a kitchen. There's some public restrooms. And so she's hired me because I'm a certified access specialist, and she wants to be in compliance to all the laws that she's subject to. She doesn't want to be sued. She wants to be in compliance, but she doesn't know if she's compliant. So she's hired me to make an assessment and for legal benefits, okay? So she has this information. She knows that it was originally built in one date, and then she's had subsequent alterations and expansion of her space. So she has dates, which is important. So when you call a CASP, have some basic information ready for discussion with the CASP. Those are dates, areas, public areas, square footages would be nice, but dates are important. Any alterations, improvements you made along the way. So remember, applicable standards, state, federal. This slide represents all of the California standards in existence. So we're talking about from the current. And remember, California building standard. This is California law. And like most California laws, remember there's an effective date, right? But California building code is a little bit different because every 3 years during a triennial rulemaking cycle, the whole California building code is published anew. So it's republished every 3 years with newly adopted access requirements. Okay, so just January 1st, 2019, or no, 2020, 2019 CBC became effective. So that is current code. So all of that, those are all the California building codes from beginning of time. Okay, so the difference is all the way back in 1961, that had 6 pages of mainly recommendations. Okay, today, remember, 211 pages. So that's why it's important to know what your applicable standard is. So let's say for a serial litigant, so in California legislature has termed serial litigants that for access violations, high frequency litigants. So high frequency litigants, most of the cited violations are to the applicable code. I'm sorry, to the current code. So though they might open up a current code which has 211 pages and use that to measure a really old facility for violations, right? So that's wrong. So you have to find what is applicable to that. So Mary Jo, most of her facility was built in or updated and altered in 2007. So I would look here. There's a range of dates that a certain California standard was applicable, and I would find that. So what it is based on permit date, okay? And it's not retroactive. What does that mean? It means that California law, like any other California law, it doesn't go back. So what that means is when California adopts a new California building code, it does not require existing facilities come into compliance with newly adopted code, because every 3 years, actually every 18 months, there's a potential for a new code, and there always is, because our unit writes the access provisions of the CBC. So I know. And so existing facilities are not required to comply with it. So what's compliant to them, what's applicable to them is what was in effect when that facility was built. So what does trigger compliance to the current code? It's new construction. So if Mary Jo wanted to expand her coffee shop today, she would need to be in compliance to the current code, which is the 2019 CBC. Okay. Compliance, so this is basically what it's saying. And if you are planning an alteration, keep in mind that the CBC has what is called path of travel obligation. What that is you are required to upgrade to a certain level the accessible features along the path of travel from the public way into the area of alterations. Okay, so let's say Mary Jo wants to upgrade her dining area. She would have to upgrade to about 20%. So when you're planning an upgrade, alteration, account for about 20% for access upgrades. And it says to review operational and maintenance policies, so you are required to maintain your accessible features. And now let's talk about the federal level standards. Remember, we have, this was CBC, state level, and then federal, ADA. There's 3 categories based on dates as well. You know, California is almost every 3 years. Federal, it's a little different, right? There are 3 standards at the federal level. The current standard is the ADA, 2010 ADA. And those buildings are subject to this if it was built after March 15, 2012. Before that date and after January 26, 1993, you're subject to the 1991 standard. But before that, and this is the real game changer, remember California is not retroactive, it doesn't address existing buildings. ADA said when it was enacted, it was enacted as based on January 26, 1992. Any buildings built prior to this date, 1992, you need to remove barriers. So it's called readily achievable barrier removal. And that is directed at you, the business owner. So ADA says, the feds say, you need to remove barriers that is readily achievable. And so you only get to decide what that is. There is no definition because it's so ambiguous, right? Law likes to use ambiguous terms like readily. You know, who's to define it? Because you ultimately have the power to decide what is readily achievable because you have the responsibility if you're ever challenged with an construction-related access violation, right? And a lot of what is readily and the standard for that is based on your financial capabilities. And so what ADA said was, it doesn't matter how old your building is. So, because some owners are thinking, hey, I'm grandfathered in. There's no such thing as that. Some owners might think, my building was built in like the 60s or the 50s before any standards were in existence. They may not have a California standard because the first California standard came in 1970, right? But federal law says it doesn't matter how old it is. If you provide goods and services to the general public, you need to remove barriers, okay? But it does, for pre-ADA buildings, those built before 1992, it does say the standards are not so stringent because it takes into consideration that these are older facilities that started off, right? For example, a stepped entry, do you see where it says, requirements less restrictive and assistive services must be provided. So let me give you an example of that. Let's see there's a stepped entry and there's no room to install a ramp, to ramp that entry to make it compliant to the access provisions because let's say it's along a street sidewalk. So what ADA says, existing pre-ADA buildings, these really older facilities, you can provide assistive service. What that means is you can provide a phone number where the individual wheelchair can call you for delivery or help or assistance, or you can provide home delivery, so that type of service. And what this says is for those buildings that were built after the enactment of ADA, after 1992, you are expected to have complied with one of these standards because they were in place. So either you're in compliance with the 1991 standard or the 2010 standard. So after we talked about, I examined Mary Jo's coffee shop, she gave me the dates, I have identified the applicable standards. Because if I use the current standard to make an evaluation, I would be identifying a lot more violations that are not violations had I used the applicable standard. So it's important. So that's an important message. Don't use the current standard. And so what happened in 2008 is California legislature said there's still a lot of business owners who are getting sued because they're not in compliance to the laws that they're subject to. So let's help them. So that's how they Certified Access Specialist program was created in 2003. It was to connect CASPs with business owners to help you guys become compliant. So we're the educational resources. We're going to guide you through this process with a lot of information because, like I said, it's a bit murky. It's not clear, right? So RASCA, that stands for Construction-Related Accessibility Standards Compliance Act. And what that means for you guys right now is you hire a CASP, you get information, you get compliant, you get legal benefits. And so you hire CASP. So Mary Jo and I spoke. We had a meet and greet. We're going to, written service agreement's going to be signed because I have standards that are placed on me because I'm a CASP. That's a professional, right? And so I'm going to perform an inspection of her facility. I've determined the applicable standards. I'm going to give Mary Jo a written report that is written in accordance with California law. So California law, RASCA says, CASP, you write it this way. Because, while Mary Jo can go to other professionals for access consultation, only a certified access specialist is authorized by California law to provide services that offer these legal benefits. Okay? And so I'm going to give her a report. That report is confidential because, remember, that report, I'm going to be identifying all the violations on her property. She shouldn't be sharing that with anybody. And in that report, there's going to be a schedule that's going to create an action plan for the owner to remove her barriers. And so that's going to be where the business owner, you guys are proactive because the law says, California legislature says, we'll give you legal benefits, but you guys have to demonstrate proactivity. And the way you demonstrate proactivity is by removing barriers that are identified in your written report. And what's interesting about RASCA was it actually created a new legal procedure whereby the business owner would be able to represent themselves in a legal setting, right? Minus the attorney, no offense. She's an attorney. So, because, these small business, thank you. So these small business owners, they don't have a lot of money and they have a lot of fears. So this whole system was to remove the necessity for an attorney. But, there's some times where you need a specialist, like I said, to hire a CASP, to hire an attorney. But this RASCA, and this is really applicable in state law, not the federal courts. They can represent themselves in the legal setting, and these are the legal benefits, a 90-day stay. So if an owner is filed with a claim, they can request a 90-day stay that halts all legal activity so that there's no opportunity for attorneys to rack up bills, right? Because that's where the big money is. And early evaluation conference. So what that does is the court system, I believe it's 50 days. They have 50 days, and the owner will be seen by a judge where their case will be heard. And the owner will use the contents of that report to evaluate the merits of the claim. And hopefully something will be sorted out. And reduction in statutory damages. So currently under the Unruh Act, the statutory means as stated in law. So for an access violation, for example, it's $4,000 per occasion, not per violation. This is wrong, that's wrong, that's wrong. No, per occasion, per visit, not per violation. Because can you imagine some stores have unintentional violations that are just everywhere. They're not going to be dinged $4,000 per violation. It's per occasion. And so these are the legal benefits that's available for proactive business owners to exercise. And so I'm going to go through now the RASCA report. So this is the report that offers you legal benefits that only a CASP can write. So following a thorough investigation or an assessment, an inspection of the facility, I'm going to make one of two determination. Meets applicable standard. That's like everything is just compliant. It's compliant. That rarely happens, right? It's most likely inspected by a CASP. What that means is there are violations and deficiencies and corrections are needed. It's important to note is that either of these two determinations, both determinations, you are offered legal benefits. And the legal benefits, why, okay, so the legal benefits are offered to someone, a business owner who has a CASP inspection and a report before the access claim is filed and made, okay? But during the time the owner is removing barriers on their facility, they can still be sued because technically access is still being denied. And that's where these legal benefits come in. That's where when it's exercised. So inspected by a CASP, so remember that means that there are deficiencies and corrections are needed. So when I perform this inspection for Mary Jo's Coffee Shop, I'm going to identify all the areas she wants inspected, because those are the only areas that are going to be covered with this legal benefit, this legal protection, okay? So what is recommended is you have all your public areas you open up to public use, we recommend you have those inspected. The top 3, every year there's a top 10 rank of access violations filed. And top 3 always is related to parking, FYI, okay? Because, if they can't park there to get into your store, then, so it's kind of obvious. It's before they enter the store. So FYI, parking, top 3 every year. So only those areas inspected. Am I going over? I don't see a clock. Where's? You're fine. Okay. Because there's actually a lot. And then I'm also going to be identifying all the access violations. So I've got my applicable standards. And by the way, you can choose to make an assessment of your facility to the current standard. As long as you know that it's going to cost likely going to cost more time and money to remove barriers, right? Because it's a higher bar. So I'm going to make a list of things that are in violation of the access provisions, access requirements. And then along with the list, we create a reasonable timeline, a reasonable schedule for making corrections. And again, another ambiguous legal term, reasonable. Who defines reasonable? It's you, the owner. So the CASP will sit down with you and say, well, how long do you think it'll take you to install a ramp? Based on a lot of other factors, like most likely financial, timing, and to name a few, the owner will say, well, that might take me 6 months. So there's a back and forth with the CASP and you. So you need to determine what is reasonable to you. How soon do you think you can raise or install a grab bar in your restroom? That should be less than a week, right? So what is reasonable? So you have an action plan to remove your barriers. So we're talking about the schedule of completion for each of the corrections. And that's how you demonstrate your proactivity, is how well you remove barriers based on what you have determined to be reasonable. And then this is created by the legislature, is a disability access inspection certificate. And it is basically a record of inspection, right? If someone comes into your store and say, I want to see your written RASCA report. No, that's a confidential legal document that's only for you. And if your attorney says you must share it, there are only certain areas or times where you need to share that information, but you don't need to show it to anyone else. So this shows proof that you had an inspection in accordance with RASCA. And what it conveys, the legislature's thought was that if you hang this on your wall, on your storefront, we recommend that you make a color photocopy and then secure the original in a safe place. This is basically saying, I know my rights, I know what I need to do, I'm on my way to achieving compliance. Okay, so if you're not compliant, there are more incentives. There's the reasonable schedule, right? So the owner is removing barriers at a time frame that is reasonable to you. And it could be whatever length, right? It's not defined in law, right? So the CASP hands you the report, handing you the baton. I'm done, now it's Mary Jo's turn. Her work begins, she needs to start removing barriers. Okay, so these are the two options. You have the option A. These are terms that DSA has coined. It doesn't mean anything in law. Option A, reasonable time frame, you're making reasonable corrections, or 120-day schedule. So state legislature, they're always looking for really, new and better features to really motivate you guys to come into compliance with long-standing access requirements. So this one came out and became effective January 1st, 2017. The 120-day schedule. What it says is, if you get a CASP inspection and you commit to removing all your barriers in 120 days, and it could be extended to 180 days in specific circumstances, okay? If you are sued during that time within the areas of inspection, you are not liable for statutory damages. This is a very popular it's a popular incentive that a lot of business have used to just sort of, I'm going to achieve compliance. But this one is qualified business owner. So, you guys are probably fit this qualification. It is 50 or less in the last 3 years. So before you call a CASP, remember, know some dates, improvement history of your facility, any alterations that have, and if you don't know it, that's okay. But it's nice to know it. It's good information, because I was able to use that to identify Mary Jo's applicable standard, so that I'm not using today's standard, which is a higher bar. Read the lease with the landlord to see if there's a CASP inspection. Review operational policies and maintenance policy where you are vulnerable. If you're faced with a demand letter or an access claim, consult with an attorney with a specialty in access litigation. Remember, statutory damages limit to $4,000 per occasion, not violation. And if you are not what's called a qualified defendant, that means if you don't have a CASP inspection and a CASP report before the access claim was filed, you can still call a CASP. It's not too late. You can call a CASP to determine if there's merit, if the filed complaint has merit to the applicable standard. Because remember, most people will cite it to the current standard, so it might not be valid. And CASP, we perform other services as well, plan review and consultation. So during the plan process of your alteration or your new building, we can help with the plan, perform a plan review of your plans. Just for buildings, a DSA, Division of the State Architect, has really rich information, very informative, just for business owners. It's a certified access specialist, property inspection. Best way is to perform an internet search. Type in DSA CASP, property inspection, or you can type in business owner, and it'll take you here. Those pluses, see that says business owners, FAQs. You activate each, and then each of those bars it's really information rich. I recommend you read through that. It has a lot of good information. So anything that DSA publishes and makes available for public consumption is thoroughly vetted. It's excellent information. List of CASP. So how do you find a CASP? So what I've done is there is a search feature in the list of CASP. And how do you find this list? You can find it from here, but you can just perform an internet search. DSA list of CASP, and that should be the first search hit. In the search all columns, type in Los Angeles County, because it's by county. But if you want it closer, for example, this area, Laverne, is 909. You could type in 909, and it will identify all the certified access specialists with a 909 area code. And you want to look at due inspections. There is a column entitled due inspections. If there's a yes, that certified access specialist is available for hire to perform inspections. So what you want to do is say, if you want a general non-RASCA report, there are no requirements, you state that. Or if you're interested in legal benefits, you say, I want a RASCA report, I want legal benefits, because there is a difference. Not all certified access specialists perform services for a RASCA report. And I invite you to call me anytime if you have any questions. My contact information here is, please feel free to call me. That's part of my work. And get listed. So here's another opportunity to get your name and address on a larger publication, large scale, DSA webpage. So if you want to advertise that you're working towards reaching compliance and you have a RASCA report, there's a way. It's a get listed form. And what happens is your name will be, your business inspected will be added to this list that's hosted by DSA. Just for businesses. Now, this is, some of you might be interested in web accessibility because that's, I've got some stats for you, but this is at the federal level. From 2017 to 2018, there was a 177% increase in the incidence of claims that websites are not accessible, because the courts haven't really determined, there's some are saying that basically websites are a place of public accommodation. Because remember I said that feds, if you are a public place of accommodation, you need to provide accessibility. So websites, DSA, we are really more, physical environment, accessibility, providing requirements for the physical environment. But what I'm forwarding to you is our sister agency, which is DOR. So I tested this out last night. Type in DOR website cool tool kit, and you will get this. This is, it has really good information, because what they've done is they've taken the standards that we as state agencies are subject to, because all our website is subject to requirements to make it accessible. So they've taken that and they've created a really nice toolkit for you to use. Thank you. That's it.
While Leah gets my presentation loaded up, I'd like to introduce myself. My name is Janie Davis, and I'm the Deputy Executive Director of the California Pollution Control Financing Authority. It sounds funny that the Pollution Control Financing Authority would be at an ADA event, but I'll give you a little background on that. We are the Pollution Control Financing Authority, and we started as a conduit issuer of tax-exempt bonds for pollution control facilities. During the 80s, we collected a lot of fees from large businesses and then wanted to use those fees as administrative fees to give back to small businesses. And from there, we started what's called the California Capital Access Program. And we have a very successful loan loss reserve program that helps small businesses that might not otherwise get funding for small business purposes, startup, tenant improvements, bridge financing and things like that. Based on the success of our longstanding CalCap program, as Debbie mentioned, the legislature likes to do what they can to provide incentives to small businesses to become ADA compliant. And they tapped on us they gave us some funding to use our loan loss reserve format that was established through our CalCap program to provide a loan loss reserve program for small businesses to become ADA compliant. So that's the how I got here kind of portion. So I gave you a little history of the California Pollution Control Program. And then our CalCap ADA program, I'll give you an overview. As I mentioned, the CPCFA, we're generally in the business of simulating the economy, cleanup, economic development through tax-exempt bonds, credit enhancements, and grants. We're a conduit issuer of tax-exempt bonds for large and small projects. We do financing for small businesses and large businesses. We fund a lot of the garbage trucks, MRFs, the materials resource facilities, and recycling type projects. From the fees that we collected, we started the California Capital Access Program, and we also have what's called the Cal Reuse Program. And the Cal Reuse Program is one, we've exhausted our funding, but we're looking for more funding. What that program is it helps brownfield projects, developers of brownfields projects, clean those properties up, dry cleaners, landfills, rail yards, things where the dirt is dirty and contaminated in exchange for affordable housing. That's a program that's been very successful. We had about $60 million in that program initially, and we've built, at build out, we should have about 8,000 new affordable housing units out of that. So we're looking to get recapitalized on that, but that's been a very successful program. As far as the CalCap ADA program, what the goal of the program is, and as Debbie mentioned, the legislature looked for a way that they could incentivize small businesses to become ADA compliant. So they looked to our CalCap program because we do facilitate private loans to small businesses in support of physical alterations and retrofits to businesses so they can become ADA compliant. We work with a menu of lenders. The lenders, we have 2 lenders enrolled in the program. Those lenders participate in our regular CalCap program, but we facilitate loans. We provide a contribution to the loans for them to enroll loans in the program. The maximum loan amount for this program is $50,000. The legislature really wanted to target very small businesses. Initially, they started with 15 employees of 15 or fewer. We've now increased that. It's up to 30 or fewer. While the loan can exceed the cost of the items identified in the cost estimate, which I'll get to, the amount enrolled in our program is limited to the eligible cost for ADA compliance. In our loan program, the lenders set the terms and conditions of the loans pursuant to their usual underwriting standards, and depending on the credit of the small businesses, those loans can be short-term, long-term, have a fixed or variable rate, and they can have any type of amortization schedule. We really do leave it up to the lender to look at the credit of the small business. As far as the ADA, the businesses that are eligible to participate in the program, we would let the legislature really as I mentioned, really wanted to make sure we were targeting the very small businesses. So those facilities need to be 10,000 square feet or less, and with 30 or fewer full-time equivalent employees, or less than $5 million in gross annual income. We have increased that. That was when, as I mentioned, it was 15 or fewer before, and it was 1 million, but that became, we realized that really wasn't feasible for most businesses. The loan enrolled proceeds can be limited, as I mentioned, to 10,000 square feet, but they're for existing buildings. The legislature really wanted to make sure that this wasn't for new construction or expansion, business expansion, that was for existing facilities. Hotels are not eligible for the program. They did not want any overnight accommodations to be included in that. And as I mentioned, the qualified loan limit is $50,000. The costs that are eligible to be enrolled in the loan are the price of construction, purchase price of real property if that's necessary, price of demolishing or removing any buildings or structure. You can see the list here. Amount of reserves for principal and interest, price of engineering, financial and legal services, and other service contracts, the price of plans, specifications, studies, surveys, estimates, administrative expenses, and other expenses or funding necessary for the project. Those are all includable. We do require, based on Debbie's presentation, that the small business obtain a certified access specialist report in order for the loan to be enrolled in our program. And the purpose of that is so that we can make sure, we ask for an estimate from a contractor too, to make sure that the loan is being enrolled for ADA compliant purposes. So we don't ask for the certified access specialist. The lender can look at the certified access specialist report, compare it to the cost estimate, and certify to the fact that those costs are included in the loan. Because we are requiring the CASP inspection to be done, and as an added incentive, last year we went to the legislature and asked if we could provide a reimbursement towards a CASP inspection. So we do. We offer 5% up to 5% of the loaned roll amount to be rebated back to the small businesses towards the cost of the CASP inspection. So the estimated cost will be compared to the CASP report, as I mentioned. As I mentioned earlier, the total loan can exceed the cost of the items identified in the report. However, our enrolled amount and the amount that's protected under our loan program is just based on the ADA compliance deficiencies. And the loan, if there's a loan proceeds, whatever's loan included in the loan does not need to cover all of the items covered in the CASP inspection. If there's just a portion that they want to, that the business or you want to enroll in the loan, that's fine. It doesn't have to include all of them. This is an overview of how our CalCap program works. We encourage the small business to contact the CASP for an ADA inspection report. At the same time, they reach out to one of our participating lenders, and then as they get their cost estimate, then provide those to the lender, and the business can apply to one of our lenders for financing. Once the lender and the small business agree to their loan terms, the lender will make a loan to the small business. The CalCap program would approve the fees and the contribution. The borrower at that point can submit a request for reimbursement for the CASP report, and the loan will be enrolled in our program. Then we deposit a portion into the lender's loan loss reserve. The lender contributes their fee to the loan loss reserve. The borrower contributes their fee, and then the lender has a pool of resources to use in their loan loss reserve. Should any of their loans go into default, they can then call on that loan loss reserve to make good on their default. This is an overview of how the rates break down. The lender pays between 2 and 3.5%. The borrower pays between 2 and 3.5%. We contribute 4 times whatever that amount is, so that would be between 8 and 14.5%. Then if the property is in a severely affected community, which we have defined in our program based on income of the area, we contribute an additional 2 to 3.5%. So the maximum amount that would be deposited into the lender's loan loss reserve is 14.5% to 24.5%. So that's what would be in the lender's loan loss reserve should any of the loans so that will be enrolled for each loan. then the lender should, any of the loans that the lender has made for the purposes of this program, they can tap into that reserve. When the loan is matures, we'll recapture our portion of the contribution so that we can make more loans to more small businesses. So we do have a recycling feature. This is a list of our current participating lenders. The list kind of ebbs and flows based on, we encourage, this program is different than some of our other programs. You'll see if you go on our website, this list is a little shorter than our regular CalCap program, but we encourage, there's a lender in Fresno and one in Sacramento, but it's very easy for lenders to enroll in our program. We provide an educational component, we do training, we'll go out and we'll meet with a lender, we'll have phone calls with a lender. If there's a small business or you as a small business have a lender that you're comfortable and familiar with doing business with, we can enroll them in our program and they can get the benefit of the loan loss reserve. So we welcome that. We welcome new lenders to the program all the time. As you can see, the links, I provided the links here to the lender registration. And then here's our contact information, our main CalCap ADA webpage. We have a really good borrower contact page to resources for borrowers and small businesses. Questions can be sent to our CalCap inbox. We have 2 managers assigned to this program, and then I'm the outreach manager. I've got business cards here, happy to take your questions. In addition, since this is always a really good opportunity, I mentioned earlier that we have an overall California Capital Access Program. The legislature, that our overall program would be the CalCap for small business. As I mentioned, it's perfect for working capital, startup costs, other typical credit needs that a small business might need. It can be for equipment in addition to construction or renovation. We also have a CalCap seismic safety program, and it's very similar to this program, but it's to help small businesses help property owners and small businesses if they need to retrofit their buildings for seismic safety. In Los Angeles, there's ordinance, several communities in Los Angeles, there's ordinance for mandatory retrofits of structures, residential and commercial residential structures, to become ADA or to become seismically safe in the event of an earthquake, so we don't lose that housing should there be an earthquake. We have a program for that. One of our most active programs is the last one mentioned here, the Air Resources Onboard Heavy Truck Program. There's requirements that the California Air Resources Board has for the age of certain trucks to try to improve the pollution and air quality in California, and we help those small fleet owners purchase new trucks by providing financing for them if they might have difficulty getting financing somewhere else. We've actually enrolled almost a little over 25,000 loans in that program. We have a program to help small businesses install electric vehicle charging stations, again with the state's need to want to improve the air quality and our goal to get more electric vehicles on our roads. We can help with the financing for electrical vehicle start charging stations, and then we have a collateral support program too, which tends to provide larger loans for small businesses that might be credit worthy but don't necessarily have the collateral to be able to get those loans. So this is our menu of California Capital Access programs, and that's just for the benefit of all of you as small businesses. And encourage you to follow us on Twitter. I'm going to tweet about this as soon as we get done here, and we thank you for having us today. Is there any questions? Thank you. Oops, okay.
Yeah, just trying to undo the cord here.
Hi there. My name is Karen Palmaro. I'm a partner with the law firm with Jones and Mayer, and we represent primarily customer needs. I don't have a prepared slideshow. I just wanted to highlight a few things and then you can kind of questions. The other thing is we've done a wonderful job of talking about
physical improvements and ADA access, physical access issues. But there are some really significant other ADA issues that are very important to businesses, both with respect to your customer base and with respect to your employees. So most of what we've been talking about before is more about customer accessibility, which I don't want to discount, that's very important. But also ADA access for people who aren't physically present and or for your employees. Those are two things that you really need to keep in mind as you operate your business. So first of all, with respect to employees, the ADA requires that you provide a fair and equal opportunity for people who have disabilities to be employed in your workplace. So what that means is that if they can perform the essential functions of the job, essential functions is a critical thing. That's the key functions of that particular job. So the job might require them to be able to interact with customers, speak with them on the telephone or in person. It may require them to go to certain places, to be able to engage in in-person meetings, et cetera. So you have to really focus on what are the actual essential functions of that job, and then you can determine if the employee, with or without accommodation, that's what the ADA says, with or without accommodation, can provide those essential functions, then you cannot discriminate against that employee on the basis of that disability. So what does it mean to say accommodation? What is a reasonable accommodation? An accommodation could be a whole variety of things. For some employees, if you do, let's say you do some sort of pre-employment written test. If you've got an employee, for example, who may have dyslexia or some other learning disability that would impact their ability to properly respond to that test, you might have to give them additional time to complete that test, to account for their disability, as long as they can do the essential functions of the job, again, with or without that accommodation. Accommodations can be anything from physical things, like physical access issues, to light duty in cases of certain disabilities, to, again, modifying testing or employment practices in such a way that the employee is able to apply for and obtain the job and perform the job. In addition, what I'm seeing right now to employee access issues, and that's everything from physical disabilities to non-physical disabilities. So you might have an employee who has PTSD or some other kind of psychological disability or mental disability that requires certain kinds of accommodation. Maybe it's soundproofing an office because loud noises startle them. It really, and again, when we talk about reasonable accommodation, the reasonableness, as pointed out by your first speaker, the reasonableness is it's not just subjective for the property owner or the business owner. It's objective. That is, what would a reasonable business in your position in terms of finances, et cetera, be able to provide to this employee? So it might be something, simple like earphones or something that's less expensive. Soundproofing the whole room might be very expensive, depending on what the employee's needs are. And so there's usually a whole range of manners or types of accommodations that could be provided. What we're looking for is a reasonable one. We don't have to bust the bank, just like you don't to address old physical barriers or buildings, but you do have to provide whatever is reasonable under the particular circumstances. One of the biggest trends we're seeing right now is about websites. So if you are a business that has a website, accessibility of your website is critical. Unfortunately, the federal rules are not terribly helpful in determining what that means, but what we are seeing is a lot of enforcement action, both private litigation and government enforcement on websites. So, for example, your website has to be accessible and usable by somebody who has vision impairments. It's counterintuitive, right? It's a website. People look at it. Well, people also listen to it. So things that you post pictures of might need to have a caption so that somebody who's visually impaired can see or can understand what is in the picture, what is depicted. Likewise, there may need to be closed captioning or some other mechanism for people with hearing disabilities to be able to access information on your website. So if you just have visuals with no auditory, maybe you don't have a problem. But if you've got auditory information on there, or say videotape that has video programming, whatever, that has an auditory component, then you're going to have to provide some way of that being accessible to your hearing impaired customers. Likewise, we are looking at things such as people who have physical disabilities which prevent them maybe from clicking a mouse, right? So if you have to go, there has to be some physical way to get access into a particular portal or location in your website, then maybe there needs to be an auditory way, a command way, some other way, a keystroke or something else that would allow the person trying to access your website to move among the different parts of your website, okay, without having to click a mouse. Some of the easy things that can be done in terms of accessibility are signs. So you may not have to make physical structural changes on your premises, but you may have to provide signage. A lot of theaters are getting claims now about not having audio assistive listening devices is what they're calling. So if a big component of your business involves verbal presentations to customers or clients, you may need to think about having those kinds of assistive devices. And one of the requirements of that is that you actually have to have a sign visible so that someone who needs that service can request it. There's actually little component pieces. They're not that expensive. They cost about $75 each that would allow you to provide that kind of accommodation to an individual who has a hearing impairment. Visual impairments can be tricky, but obviously we have things like signals that someone can tell whether the door's been opened or the door's been closed. Other kinds of things that would help somebody who has visual impairments to navigate your physical premises as well as your products and your websites. There's a lot of issues around the ADA. A lot of them are getting litigated. Physical access is just one aspect of it. So I want you to think about not only physical access when you're considering the ADA, but also look at what other kinds of access you may need to provide to non-physical components of your business, okay, and to your employees. So with that, I'm just going to summarize. Are there any questions that you have about how to address those kinds of issues that the other speakers didn't focus on very much? No questions? Wonderful. Miss Leah? Yes, ma'am.
You use the phrase breaking the bank.
Yeah.
I have heard of the concept of hardship. How would a business be able to apply or be accepted as a hardship when the accessibility, construction, or terms are beyond their financial means?
Right. So that's largely a function of the size and financial capabilities of the business. And the other factor in there is what is the cost of correcting or making that accommodation or making that physical modification. So if you're a small business and you're in an old building that would be very expensive to retrofit, unless you are doing some sort of significant remodeling or addition that would require you to, let's say, make your bathrooms accessible in an old building where they're not accessible. You have to do your best to remove physical barriers that are in place at a reasonable cost, as your first speaker pointed out. But you also have to take into it, what does that cost? Does that mean that I actually have to expand the size of the restroom? No, but what can you do to make reasonable accommodations to eliminate those physical barriers without reconstructing the building, right? Maybe it's installation of a handrail. Maybe it's removing a very difficult, what do you call them, at the doorway? You know, ledge, edge, whatever, that would impair somebody with a wheelchair from getting into the bathroom. Maybe it's widening a doorway. So there are some, what we're going to look at is what is the cost of doing it, and what is the financial capability or inability of the business to provide that accommodation. So if what somebody needed, you don't have to change the essential functions of the job for an employment accommodation, for example. And again, you don't have to break the bank. If it's going to cost you so much money that it basically wipes out your ability to do business, that's not going to be required. So they're going to look at, remember, you're going to look at what are the range. There's always more than one way. Think of it that way. There's always more than one way to potentially accommodate a need of a customer or an employee. So you want to think about that whole spectrum. So remember, think about the auditory one. It's the whole spectrum of getting them earphones to avoid the loud noises that might startle them or upset them, to the cost of soundproofing an entire room, which is an expensive proposition most of the time. So, and there's almost always going to be something in between those extremes, right? So we're going to have to look at what is it that is absolutely necessary and what is reasonable. Those are the two things. And then the reasonableness is going to be a function of how long it takes, how much it costs, and how big of an impact it has on your ability to operate your business. I hope that's helpful.
So if you meet this hardship qualification, you cannot become completely compliant because of a cost barrier, does that remove your liability from litigation?
Yeah, if you can't, if whatever the cost is to provide that quote accommodation is so high that it no longer becomes a reasonable accommodation, right? Then yeah, you can be immune from litigation. Obviously, in terms of physical barriers, it's always a good idea to make sure that you've talked to an expert, not just a contractor who might come in and give you a quote and say, well, it's this going to cost you this much. You really need to explore and be able to document your inability to provide that accommodation. Yes, sir.
I read an article about this ADA issue from San Jose Mercury. There was a very trendy coffee shop who was doing really well, and she got sued by this predatory handicapped person, and they had to close the shop because they couldn't afford upward of $100,000 to do the on-ramp or the handicap ramp. And you said it's reasonable. I'm just asking you, why should they? And they said there are quite a bit that's closing this because of litigations like that.
Yeah, and that may simply be a cost analysis that the business owner did, that whatever the cost was of complying and the whatever system they were in terms of what was the applicable regulation, what was the cost of putting in that ramp, how are you going to provide an alternative methodology for that customer to be able to come in. So you'll see sometimes in old, I'll give you a good example. There's a very old building in the city that I live in that has stairs, right, going up to the second floor. There's no elevator in that building. It also has a restaurant that's actually in the cellar, essentially. It's down underneath the main ground level. So how do they accommodate their disabled guests? Well, there's an elevator in that restaurant. It goes down into the kitchen from the backside of the parking lot, not where all the other customers come in. And then they have to go through the kitchen. It's not nice, it's not great, but it does the trick, right? It works. So depending on how much the cost is and how big that business is, if it's a mom and pop coffee shop, they probably can't afford that $100,000 ramp, right? And I would expect them to be able to demonstrate that. If it's a chain like Starbucks, it's a whole different ballgame, right? So again, you have to look at what are the capabilities, financial and otherwise, of the particular business, and whatever the needs are to accommodate that disability. Maybe you don't build a ramp in the front. Maybe there's not enough sidewalk room to be able to do that, for example, and still maintain the width that is required for ADA access for the city. Was 4 feet, right, width? Or 3 feet, 36 inches or something like that. But maybe there is a way for them to enter in the back. Maybe there's an alternative way to provide that access. Those are the kinds of things that we have to look at. Maybe you don't have to install a whole elevator. Maybe it's a small ramp. Maybe it's one of those electronic lifts, you know what I'm talking about, that can lift up a short flight of stairs, something like that. So it's all relative, in short. Anybody else? Great. Well, thank you so much for your attention, and hopefully if you have questions, you can pass them through Ms. Leah, and we'll do our best to help you out.
So thank you so much for joining us this morning. This has been presented by the Laverne Chamber of Commerce along with the City of Laverne. Video is being created and will be posted on our website. Again, if you have additional questions, you can reach out to me and I will be more than happy to put you in touch with our secretary.